Okay, will we start? Good afternoon, everybody. I'm Cjeu. I'm the president of Dublin City University, and I'm delighted to welcome you this afternoon to this Brexit Institute event, the first one of our new academic year. And today, the discussion will be on the really big question about legal disintegration. Not just Brexit, but the judgment of the German Constitutional Court and the future of Europe. If nothing else, the Brexit Institute has never shied away from big questions. So that's, of course, the purpose of a university, and that's what we do here at Dublin City University. I'd like to welcome everybody around the room. There's some familiar faces there, so welcome to friends, and particularly welcome to new friends, particularly those who, if this is your first engagement maybe with the DCU Brexit Institute. Again, just looking at the names around the table, I can see colleagues here from France, from the United Kingdom, from Germany, Luxembourg, the United States, and of course from across Ireland. This is our fourth year of the DCU Brexit Institute. Federico will tell you that it's Ireland's only, it's Europe's first centre established to analyse, I suppose, Brexit from a research and policy perspective. At the outset, we may have thought that we would have exhausted those questions fairly quickly and that we were satisfied maybe with the definition that Brexit is Brexit, but that debate has rumbled on, and here we are in our fourth year. The last 12 months have been very busy for us, and Federico, as you know, and Catherine and the other colleagues, not even a pandemic could stop their enthusiasm for debate on policy and practice in Brexit, and we've moved forward. You can see too from a lot of the recent events of the Institute that we have broadened our activities beyond, I suppose, Brexit in a kind of an Anglo-Irish focus that many of the institutes dwell on, but that we've developed our activities across Europe. We were pleased last October to launch the Bridge project, which was a major EU-funded academic network which was led by the Institute that assesses issues around European responses and governance responses to the European crisis. We will host next month the second Bridge conference, and that will look at COVID-19 and the future of Europe. So put that in your diaries, please. Federico will point that out. Significantly too, in terms of the funding and the ethos of the project, that the Bridge project will launch its first online learning course, and that will be entitled the European Union Crisis and Recovery. So that will be available for online teaching modules that people may decide to use. We'd also like to welcome a new partnership with the Villa Vignoni, which is the German-Italian Centre for European Dialogue. Again, it's a significant development for us. Today's discussion is on the judgment of the German Constitutional Court in Weiss, and it reminds us that it's not just Brexit or COVID indeed that's straining the European Union, and our colleagues will tease that out today. Somebody sent me a text this morning in the context of COVID, reminding me of Jean Monnet's words for a situation like this, where he said, the important thing is not to be optimistic or pessimistic, but to be determined. And that determination to push through. I'd like, on your behalf and of the colleagues around the room, all 53 of us, to welcome our distinguished panel and thank them for joining us today for the debate. There was a little kind of warm-up chat, so they're all kind of revved up and ready to go for this discussion. So I'd like to thank especially Lord Thomas, who's a member of the British House of Lords, former Lord Chief Justice of England and Wales. I'd like to welcome Amelie Champsaur, who's a partner at Cleary Gottlieb in Paris. I'd like to welcome Mark Dawson, who's a professor of law at the Hertie School of Governance in Berlin. My own colleague, Federico Fabbrini, who's Italian, and who's professor of law here at DCU and director of the Brexit Institute. I'd like to welcome Daniel Kelemen, Professor of Political Science at Rutgers University. He doesn't need any new Twitter followers, just to warn you. important that we make this, that events like this wouldn't hugely grateful to them. I'd like to especially thank the sponsors of today's event, Cleary, Gottlieb, for their generosity, and also to announce to our core sponsors, Allied Irish Banks, Grant Thornton, and our newest sponsor, GSK Stockman in Luxembourg. Stockman is a leading European law firm, as you'll know. They have offices in Luxembourg and Germany, and their support will help us expand the remit and, I suppose, the life and the potential for reflection of our institute at a critical times in European-UK relations. Significantly too, I think that their endorsement is a reflection of that kind of broad character, international European character of the institution that I spoke about earlier. And finally, I'd like to thank all my own colleagues here in DCU, at the Brexit Institute and the Research Centre. In particular, I'd like to thank Federico, who was the genesis of the Institute, and there's no point in having a genesis if you don't have somebody to keep it together. So Catherine Martin will do that for us today. So welcome to the DCU Brexit Institute, and thank you very much again to our colleagues, our presenters and our sponsors. Thank you. So I'll hand you to the Federico, who will introduce the rest of the debate. Thank you, Federico.
Thank you very much, Dara, but I will immediately pass on the floor to Mary from the Irish Law Gazette, who will be our chair and moderator for the panel this afternoon, and she will be introducing our speaker. Thank you again, Dara, and thank you, Mary, for being with us. The floor is yours.
Thanks, Federico. Hi, everybody. My name is Mary Hallissey. So I'm a journalist with the Law Society Gazette here in Dublin, and Federico has asked me simply to introduce the speakers today and to moderate the event. So today's session will run for 90 minutes. So we're going to be wrapping up promptly at 5 p.m. So I could just ask everybody to keep your contributions kind of brief and to the point. And in the interests of audio clarity, all questions should be submitted by the web chat feature, which is on the bottom right of your screen. So if you write in your questions there, I'll pull the most interesting ones out and submit them to the speakers. If you have any technical difficulties, you can contact the admin, which is Catherine there. All of the mics will be muted apart from the speaker in the interests of clarity as well. So we're going to be addressed first of all today by Lord Thomas, who's going to make the opening remarks. And Lord Thomas was Chief Justice of England and Wales between 2013 and 2017. He's a member of the House of Lords EU Committee. He is President of the Qatar International Court, first Vice President of the European Law Institute, of which he was a founding fellow, an arbitrator at Essex Court Chambers, Chairman of the London Financial Markets Law Committee, and also he is Chancellor of Aberystwyth University in Wales. He was at the Commercial Bar in London before becoming a judge. He's President of the European Network of Councils was President of the European Network of Councils for the Judiciary from 2008 to 2010, and was Chairman of a Welsh Government Commission on the operation of the entire legal system in Wales, which reported last year in October. So thank you, Lord Thomas.
Good afternoon. I was going to speak primarily about Brexit, and I want to use this and what's happened very recently as an illustration of how important it is that we have a clear legal order, and how important it is that we see that many of the difficulties that have arisen and will arise do require a much better common approach. And in particular, we need to be conscious of the fact that legal development in the digital age, or in dealing with a pandemic like COVID-19, we all share common values and common principles, and those should be at the basis of our approach. Now, I'm going to start by saying a little bit about the current problems that have arisen in relation to the Northern Ireland Protocol, because it illustrates the difficulties of the Brexit process. I don't think the Brexit agreement is in itself a very lengthy and complex document. and it's not always easy to follow. But the Northern Ireland Protocol being agreed at the last moment and being agreed under enormous political pressure has actually produced a document that is not very easy to follow. It attempted, in essence, to reconcile to preserve the peace process, the position of Northern Ireland as part of the United Kingdom, to avoid a hard border with Ireland, and at the same time keep Ireland's position and the EU intact. Now, it is clear that there were difficult issues. And one of the functions of the EU committee on which I sit, but I was not present, not a member of it when it dealt with the Northern Ireland Protocol initially, which it dealt with in its report of the 28th of May of this year. And I think that that report shows that actually a very great deal of careful attention needed to be applied to, and in particular, Articles 4, 5, 6, and 10, because they attempted to deal with with what many think are irreconcilable positions. But they required an approach that when you got to a difficulty, that people understood that there are certain intrinsic features in the legal order. I'm not going to go into the details of the protocol because time doesn't permit. But the difficulties of a wrong process have been highlighted by the bill the British government brought to the House of Commons in London this last week. And it essentially provides that notwithstanding the agreement it reached in the protocol, it can override certain of its provisions. Now, there is, I don't think, any dispute any longer in the UK, and I hope nowhere else, that the rule of law requires compliance by a state with its obligations in international law, just in the same way as in national law. And I think this is a fundamental principle that sometimes we forget. But in those who want to have the necessary close relationship to ensure that European legal order looked in Europe, not as just the EU, but as a whole, goes forward, is of great importance. Now, the British government at first thought that it could use parliamentary sovereignty to justify the fact it was not breaching the law, the rule of law, but what it was doing was merely applying the powers of a sovereign parliament. But although the Vienna Convention on the Law of Treaties is not applicable to the EU, everyone agrees that its provisions apply as expressing customary international law, and that a party can't invoke its provision of its own internal laws, which is the exercise of parliamentary sovereignty, to justify failure to perform a treaty. Now, it is not, as I speak now, and I wouldn't wish to develop it, clear what the exact position of the British government was. I think it currently accepts that what it wants to do is a breach of the treaty. An attempt was made last week to try and explain that it wasn't, and a further attempt was made at the beginning of this week, but that I don't think is being applied, though some of the justification for the position taken is based upon apparent failures of the EU to stick to the treaty. The EU position is very clear. It thinks the treaty should be, the protocol in particular, its provisions should be applied, and that the various dispute resolution mechanisms should be applied. And I think what is important for this, for the future, are two things. First of all, dispute resolution mechanisms must be thought through much more clearly. Any commercial lawyer or commercial litigation law knows that people don't pay enough attention to dispute resolution clauses. And they're often the last thing agreed, and you sometimes get problems with them. but I think it should have been apparent that this treaty would cause problems, and the protocol would do so in particular. And so it is absolutely essential to have proper dispute resolution mechanisms, and those that could actually operate speedily and provide for proper interim decisions. And both parties ought to have confidence in using it. And it's a matter for regret that as it appears there's a dispute, the British government has not invoked those mechanisms. But I think equally important are the way in which lawyers ought to, and states ought to approach things. And I think both in the UK and in the case of the EU, and one can see this happening very clearly in the US, that we forget at times the importance of constitutional conventions, what the spirit of the Constitution is, how you balance the roles of various people, and you don't act without using all these mechanisms. And in the UK, it's been quite interesting to see that two of the mechanisms so far have worked, namely the convention that the civil service should do what it can to uphold the rule of law. And secondly, that the law officer's duty is to uphold the law, have in part been vindicated by the resignation of the head of the legal service and the resignation last night of the third law officer of the Crown. And I think that it is, to my mind, important that we do everything we can to strengthen these conventions, which are the glue that holds everything together. But I think, therefore, that what the Brexit protocol dispute has done is to ensure that these matters ought to receive much greater attention than they have to date. Now, why I say these matters are of universal or much wider application is that it does seem to me, looking at issues in Europe, that we forget that the rule of law is of fundamental importance. It's brought home to me time and time again in the European Law Institute how the way in which the judiciary's independence is under threat in Poland and Hungary is a very strong worry in relation to the rule of law, and it does have implications for the long-term legal stability. And in this connection, I think it's important also to realize that the rule of law and a common approach was essential to the way in which we dealt with the pandemic, that although governments had to take action, they had to be held to account either by the legislatures or by the courts. And I think an issue that needs to be gone into in much greater detail is the precise role of the Conseil d'Etat and of the administrative judges in intervening. So the rule of law and the way in which these issues are dealt with are of fundamental importance, not only to what is essential, that is a proper relationship between the EU and the UK, but also to the EU itself. And I very much hope, therefore, that when we are moving forward, we do realize we have a common legal heritage. There are areas which I won't speak about at the moment, such as the way in which our legal systems have to have a degree of commonality, as they have over the centuries in relation to international trade, but now in relation to the digital revolution. And how, although if the EU proceeds with the Conference on the Future of Europe, it does actually realize that the EU is not an island, but actually is a bit more like the UK in a bigger sphere. And it must therefore see the point of view from a much wider perspective. But its basis must be the rule of law, and lawyers must do everything to improve the mechanisms by which that is upheld. Thank you very much.
Thank you, Lord Thomas. That's very interesting. We'll move quickly along to our second speaker, who is Amelie Champsaur, who is a partner at the Cleary Gottlieb office in Paris. And Cleary Gottlieb has actually sponsored today's Brexit Institute event. So Amelie specialises in EU and cross-border financial, regulatory, investigative and compliance matters. She was recently recognised as one of the 40 under 40 rising stars for legal services in the EU by Financial News. She also received her LLM degree from Harvard Law School in 2005 and is a member of the bar in Paris, and she's also fluent in 4 languages. So hats off to you, Amelie. Thank you.
Thank you, Mary. So I will speak about the ruling of the German Constitutional Court last May, which was quite a thunderous event among EU lawyers. The reason why this ruling was so shocking from a legal standpoint is, I think, threefold. The ruling, which, as you all probably know, indicated that the ECB had violated EU law, that the EU General Court had also violated EU law, concluded that the German Bundesbank would be prohibited from participating in the program that relates participating in the debt program that was launched by the ECB unless the ECB was able to provide to the court a justification of proportionality. This ruling of the German Constitutional Court was indeed extremely virulent in attacking the judgment of the ECB and of the EU General Court. It found that the EU General Court had violated EU law in its own Weiss judgment, and that the ECB had violated EU law by not justifying its action as part of this financing program. And so this was a first insofar as while the German Constitutional Court had previously ruled on the fact that the EU authorities would be exceeding their competencies in those circumstances, it had actually not ruled that as a practical matter, but it did so in that judgment. The second aspect of the ruling that was surprising was that instead of challenging EU law and instead of being a disagreement between the EU court and the German court as to the substance of EU law, the German Constitutional Court distorted and reinvented some of the key concepts of EU law, such as the proportionality principle. And so the judgment did not follow the traditional concepts of EU law, such as proportionality, but instead defined a certain standard of proportionality principle that did not have a basis in EU law. And so this was more than a disagreement between two courts as to the interpretation of EU law, but more of a subversion of some of key EU law concepts in order to reach a specific conclusion. Finally, the judgment was surprising insofar as it was coercive, and so the tactics of the judgment and the outcome of the judgment put the Bundesbank to comply with the judgment. The ECB had to provide documents and information to the national courts, whereas it is normally only answerable before EU courts. And so for that reason, the judgment of the German court put the ECB in a situation where it was going to have to violate the treaty, and in particular the independence requirement under the treaty, in order to comply with the judgment. And so while there have been a number of cases in the past where national courts, particularly constitutional courts of the member states, have disagreed with the EU General Court, this judgment went above and beyond those previous judgments, and particularly cases that arose in France and Italy, in that it wasn't so much a disagreement on EU law as clearly a manifestation of a will to subvert the EU legal system and EU concept by prioritizing a certain interpretation of EU law made by the German courts, which did not actually have any basis in German law or in EU law itself. And the judgment was criticized not only by EU legal scholars, but also by reputable German lawyers and German judges. One example of the reason why the judgment was criticized is that it led to an interpretation of some key administrative law concepts that are not just EU law concepts, but also concepts that are incorporated in the administrative law systems of the member states that were not being applied in line with even the national law of Germany in that case. And one example of that is, so I mentioned the principle of proportionality earlier, which was interpreted by the German court as meaning that the ECB had to apply an impact assessment, essentially. So had to make decisions on monetary policy by examining their impact on economic policy. And that's not what the principle of proportionality says in administrative law, whether under EU law or under German law. Proportionality principle is not an impact assessment. It's an assessment of whether a specific measure is necessary and appropriate to the objectives that it has. And so this is one example. Another example was a confusion between the concepts of competence and of excessive powers. An institution can be competent to adopt certain acts and still exceed its powers if the acts that are taken are not appropriate in light of their objectives. And so by ruling that the ECB was not competent to adopt the debt program, the debt purchasing program, and that the court itself, the EU court, was not competent to issue the judgment, and there was actually a confusion between the notion of competence and the notion of abuse of powers or excessive powers, which are traditionally two very separate legal concepts. And those are some of the reasons. I won't go into the detail given our time frame, but those are some of the reasons why this judgment was heavily criticized by EU legal scholars. It turns out, however, that the bind that the ECB, the Bundesbank were in, was ultimately solved. While the court has set a deadline of 3 months, a solution was found within this 3 month period. The ECB did not violate its independence. It did not directly respond to the request of the court and did not provide the court with the information that it had requested. What the ECB did was to publish more information about its proportionality assessment, which was, as I mentioned, not actually a proportionality assessment, but an impact assessment. But still, the ECB cooperated with the request and provided that information to the German government, not to the German courts, and that ensured that the ECB did not violate its statutory independence. The German government and the German parliament then took the step of adopting a resolution by which this proportionality assessment was found to be sufficient for purposes of the German Constitutional Court ruling. And on that basis, the Bundesbank decided that it could continue participating in the debt financing program, in the debt purchase program. Sorry. And so on that basis, a solution was found to a problem which at first seemed completely intractable. What I would like to stress here is that in this particular case, a legal disintegration was avoided in a way that ultimately is not very different from the Italian or French cases of the past, where ultimately measures are taken at national level to ensure that EU law is followed, including by reining in, if you will, the national courts. And that's also what happened in this case. And so while it started off as a very unique case, the solution was very much in line with precedents. What's important to note is that their legal disintegration can be avoided only if there is a political willingness to ensure that the legal system is upheld. And in this particular case, the German government acted extremely swift, which would otherwise for sure have been initiated by the Commission, and to remedy the issue. Without that swift intervention by the German government, the issue would be in front of the courts. The Commission would have launched infringement proceedings, or the ECB would have launched proceedings against the Bundesbank. And so, and I think that is also what differentiates this case from what is happening in Poland or Hungary. When there is not a political will to uphold the legal system, it cannot be upheld. The law doesn't exist in a void. Thank you.
Thank you, Amelie. Our third speaker today is a professor of European law and governance at the Hertie School in Berlin, and that's Mark Dawson. Mark's research focuses on the relationship between the law and policy making in the EU, particularly in the fields of economic governance and human rights protection. He was previously an assistant professor at Maastricht University and has held visiting positions at the London School of Economics, University of Wisconsin, and the Harvard Kennedy School. So thank you, Mark, and welcome.
Yeah, thank you very much, Mary. Thank you very much to the Brexit Institute for inviting me to this event. Having listened to Amelie with great interest, also anticipating a little bit what Federico and Dan might say, I've got the feeling I'm going to be sort of the odd one out in this panel in defending the decision of the German Constitutional Court, but I guess that's useful. I was commenting on in the little pre-chat that sort of I've recently become a German citizen, so perhaps I've sort of gone native in that respect, but nonetheless, let me say a few words on that. And I think this is connected, of course, to the overall idea of legal disintegration, which of course I find compelling, and there's lots of evidence of it across Europe, right? So we have the examples that Amelie already mentioned of disregard for the rule of law, judicial independence, and lots of other legality standards in Poland and Hungary. We have the potential breach of the withdrawal agreement that Lord Thomas talked about. We have, it seems, in the UK, a new defence for breaching international law, which is you're allowed to breach international law if you only do it a little bit. That seems to be the message coming out of the United Kingdom. So it seems in a sense that, you know, law is falling down all around us. So the question therefore is, well, how do we respond to that? And I think the temptation in terms of how to respond to that, at least in European law terms, is to reinforce the centre, right? So to reinforce central institutions, or to see European actors like the Court of Justice, like the Commission, as the saviours, and to criticise those institutions like the German Constitutional Court, who potentially depart from EU law standards or question EU law standards in the way that they did in the Weiss decision. What I want to do, though, maybe a little awkwardly, is to question that thesis, and essentially to argue that questioning central institutions, disrupting central institutions, or at the very least distinguishing between destructive and constructive forms of questioning the authority of European law, is actually an important part of what allows European law to work, and even an important part of responding to some of the other examples of legal disintegration that we see happening in other parts of Europe. So I see the Brexit example as part of legal disintegration. I see the Polish and Hungarian examples as part of that, but I don't see the Weiss decision as part of that. And I want to just take a couple of minutes to explain why. So what are we actually protecting when we talk about something like legal integration in Europe? Well, if you look at sort of the classical texts of European law, the famous godfathers of European law and godmothers of European law, what we're essentially protecting is the legal order is some kind of space where individuals, and not just states, can use European law, use the authority of European law to question exclusionary practices or arbitrary practices conducted by states. So this is what a lot of those legendary cases of European law were about, using EU law to contest state practices that excluded outsiders, or that defied fundamental rights, for example. And it wasn't just about using EU law to contest national practices, but also, of course, using EU law to contest EU authority that might do that, EU authority that might defy fundamental rights. So think about the Schrems case and data protection as a contemporary example of that. Now, I think there is no faithful reading of this kind of principled idea of legal integration that would defend what we see in the Polish and Hungarian cases. So there's no faithful reading of legal integration that would defend the undermining of judicial independence in the Polish and Hungarian cases, or that would defend the use of constitutional identity by captured Polish or Hungarian courts to violate or to remove themselves from EU supervision of rule of law standards. So I think the defiance of EU law that we see in those cases, it's conducted in bad faith. It's essentially being conducted to erode rule of law values. There's no way we can interpret it in its best light as a potential defense of rule of law values or in a way to forward rule of law values. My argument, though, is that there are faithful readings of the Weiss case and of the jurisprudence of the German constitutional courts that is compatible with rule of law values and is compatible with this idea of legal integration that indeed, as Lord Thomas says, we have to try and defend. So it's not a judgment that's immune to criticism. There's lots of inconsistencies in the judgment, and Amelie pointed to a number of them, including perhaps discrepancies between the way the German Constitutional Court operationalizes domestic law versus the way it operationalizes EU law concepts. But in the same time, implicit in this judgment are a lot of ideas that are also implicit in legal integration in Europe more broadly. So one idea, for example, is the idea that EU executive institutions, like the Commission, like the European Central Bank, should not have unlimited discretion to determine the range of instruments that they can use to achieve their policy objectives. Another idea is that the power of the EU institutions is subject to the principle of conferral, that the EU institutions are not the master of the treaties. Actually, it's for the member states to determine the limits of the powers of the EU institutions. Another idea is the idea of proportionality, that means that essentially certain policy options should be ruled out, that the EU actors have to somehow balance interests in a fair way when they conduct decision making, and they should avoid going beyond what is necessary to achieve their objectives. So of course you can disagree with how the German Constitutional Court operationalized these principles. You could say, for example, that maybe the interpretation of proportionality is not the one that the one that's implicit in European law is not the one that the German Constitutional Court followed, as Amelie made in her contribution. But I think there's no good faith reading of these arguments that doesn't see them as part of the rule of law tradition and attempt to defend that tradition as seen from the perspective of national constitutional orders. So I think in that sense, the German Constitutional Court got a lot of things wrong in Weiss, but it wasn't in principle wrong. There were real rule of law problems with how quantitative easing in Europe had been designed. There are real rule of law problems regarding the distributive effects of quantitative easing programs, problems which the Court of Justice of the EU in its Weiss decision hadn't adequately analysed. And therefore, there was significant room left for the German Constitutional Court to take on that role of ensuring that these core principles were enforced. So in that sense, using national constitutional law as a vehicle to force the EU institutions to address certain issues of legality, it seems to me to be part of the paradigm of legal integration, not a departure from it. Maybe I can finish just with one very brief analogy because I know I'm running out of time. So earlier today, I was reading an essay by Jeremy Waldron. So he wrote this series of essays called Political Theory. And one of the ideas that he writes about in his series of essays is called the idea of loyal opposition in politics. So of course, the idea of loyal opposition is that if you're in the opposition in a parliamentary democracy, then you have a certain duty to forward the national interest. You have a certain duty to act in good faith. But at the same time, you also have a duty to criticize and to keep the government in check. And actually to do so is not something that's treasonous. It's actually something that is part of loyalty to the cause of parliamentary democracy. Now, Waldron's argument, of course, is that in our modern democracies, we seem to have lost this idea of loyal opposition. So for Trump, there's no loyal opposition, there's only treasonous opposition. Essentially, though, I just want to finish by making an analogy to European law. So for me, creating something like loyal legal opposition in European law is necessary for its survival. We need opportunities for national actors to contest European law without destabilizing European law as such, without being seen as some kind of traitors to the unity of European law. We need to give national actors a space to legitimately contest European law in order to avoid things like exit in the Brexit case, or to avoid things like illegitimate contestation, like we see in the Polish and Hungarian cases. So with that, I'll probably finish. I'm a bit more optimistic about this judgment, but I'm looking forward to discussing it with the rest of you later on. Thank you.
Thank you, Mark. Very interesting indeed. Our next speaker is Dan Kelemen, who is Professor of Political Science and Law and Jean Monnet Chair in European Union Politics at Rutgers University, which is the State University of New Jersey. Dan's research focuses on the politics of the EU, law and politics, comparative political economy, and comparative public policy. His 2011 book, Eurolegalism, The Transformation of Law and Regulation in the EU, published by Harvard University Press, won the Best Book Award from the EU Studies Association. So thank you, Dan. Go ahead, please.
Thank you. Can you hear me fine?
Yes, thank you.
All right. So I'm going to try to touch on sort of all the themes that were raised in the title of our session. So a bit of Brexit, a bit on the Weiss ruling and the future of the EU. And I just start by saying, in terms of Brexit, you know, while many people in recent years thought Brexit might prompt other states to follow the UK out and potentially lead to a disintegration of the EU, you know, it turns out that, of course, that didn't occur, and that further exits do not seem likely at all. In fact, a large majority of Europeans favor deeper cooperation these days. So sort of exit and that kind of disintegration is not the existential threat facing the Union. Rather, I think the real existential threat facing the EU these days, well, it doesn't come from Brexit. It also doesn't come from some of the other big crises like the migration crisis or the Eurozone crisis. Really, the real threat to the EU is that a number of member states want to stay in the EU, but not to respect its fundamental values, such as democracy and the rule of law, and along with that, to not respect judgments of the ECJ that might seek to defend those principles. That's the real threat. Not that states will leave, but that some will stay and provoke this kind of legal disintegration that we're talking about. And I think we have to see the German court's Weiss ruling in that context, even though, of course, Germany isn't one of those states in a general sense that's against the rule of law or democracy, of course not, but we have to frame what's happening with Weiss against that background and those dangers. Because good faith or not, as Professor Dawson was referring to, my view, sort of what's good for the goose is good for the gander. And if the German Federal Constitutional Court can disapply ECJ rulings that it disagrees with for whatever reason, constitutional identity, ultra-virus or otherwise, then so can the court of any other member state, including courts that are captured by authoritarian governments. So, you know, turning to the Weiss ruling, I'm not going to say anything really about the substance of the ruling, which Amelie Champsaur already talked about very well. And just what I want to emphasize is that it's not really the substance in terms of you know, ECB policy that is the big threat for the EU, and that's sort of been overcome, but rather it's the implications the ruling has for the foundations of the EU legal order, as Ms. Champsaur indicated also. So, you know, essentially when the German court invalidated an earlier ECJ ruling, this was perhaps the most serious defiance of the ECJ's authority in the EU's history. And by rejecting that ruling, the court in effect said that it was the ultimate interpreter of EU law in Germany. You know, it really crossed a Rubicon with that ruling. And, you know, just to as a little aside, I want to say, since I'm talking to you from the US, I might be the only American involved here. You know, from my perspective here, knowing a little US history, you know, one has to see this ruling kind of has resonances of what we called in the 19th century, the nullification crisis, where South Carolina asserted that it could declare federal laws null and void within its state. Or more recently, in fact, when the Alabama Supreme Court for a time said that it could ignore the US Supreme Court's judgment legalizing gay marriage in Obergefell, right, saying it didn't comply with the Alabama state constitution. So this is something, you know, other kind of federal type unions have dealt with, where states are declaring, you know, that they can overrule the federal high court on these kind of questions. So, you know, back to the German case and Weiss, you know, the main constitutional point I want to make is that the judgment in Weiss is untenable in a union based on the rule of law, quite simply because, and this is something Federico Fabbrini will talk about too, he's written about a lot, if national courts can simply declare that CEU judgments that they deem unacceptable are inapplicable within their countries, in short, that would ultimately destroy the EU legal order. It would lead to its unraveling, okay? Because, you know, ultimately it would mean that national courts would be able to pick and choose which EU laws, which ECJ rulings apply within their jurisdiction and which ones don't. And so that would mean EU law would mean different things in different member states, and hence it wouldn't really mean anything at all, right? And, you know, I guess what I want to emphasize there, to get to some of the issues Professor Dawson raised, you know, that there's still the question then, how do we reconcile that with the fact that national constitutional courts are the guardians of their constitutions, right? And have, of course, every right and every duty to defend those constitutions. Well, what I'd say there is that the problem in Weiss is the remedy that the German court applied. In other words, you know, I think it's fine for a national constitutional court to say, we must be the ultimate guardian of our constitution and of our country's constitutional identity. But if they think that an ECJ ruling or just an action of the EU has violated that constitutional identity, it cannot be the appropriate remedy to simply disapply the ruling in question for the reasons I already said. Rather, because that would lead to the unraveling of the EU legal order. Rather, you know, I think what they have to do is either compel their government to try to change the EU legal norm by working through the political process, or if that's totally impossible, or if it's an unamendable part of their own constitution, something like that, then they might have to tell their government that further membership in the EU is incompatible with national constitutional identity. Fine, then they should leave, right? Which brings us back to Brexit kind of idea. If, you know, if the EU is unacceptable to you, then leave. Now, finally, just to conclude, I want to turn back to the cases of Hungary and Poland in these captured courts. The German court's ruling and its outright defiance of the ECJ is very problematic in the context of a union where we have now one member state, Hungary, which is already categorized as authoritarian by all the leading bodies like the VDEM Institute, Freedom House, and where you have Poland, which is right now sliding very quickly in that direction and is in outright defiance of the ECJ. And one need only look at how those regimes reacted to the Weiss ruling. They both embraced and celebrated it, quickly issuing different kind of statements which indicated that the logic put out by the German Federal Constitutional Court in Weiss would justify their own defiance of the ECJ, including in things like cases to do with the ongoing assaults on judicial independence in their country. Now, one could say, as Professor Dawson did, well, they're acting in bad faith, and you know, we can't blame a concept like constitutional identity or pluralism for the fact that some actors misuse it. Well, I guess I just conclude by saying, I think it sort of depends how you think about it. You know, you can't, let's say, ban butter knives because someone stabs someone with a butter knife, right? But you can ban assault rifles or, you know, personal ownership of tanks, right? And, you know, from a kind of product liability perspective, I guess, I think we need to think of some of these norms that the German court has been pushing as being inherently dangerous, right? And therefore, you know, things that should not be acceptable in the legal terrain of the EU. Thanks.
Thank you indeed, Dan. That was very interesting. And our final speaker is Federico Fabbrini. Thank you.
Thanks, thanks, Mary, and let me thank all the other speakers as well. I am slightly embarrassed to take the world here because I obviously have a dual hat. On the one hand, I'm the organizer, but I also listed myself as a speaker simply because I think the topic of this seminar are really close to my research heart. So let me just say a few quick words, essentially with the aim to reconnect conversations about Brexit and about the German Constitutional Court in Weiss. So I'll really have only 3 points. The first one is that I think exits and semi-exits ought to be considered jointly. Secondly, I'll be claiming that actually semi-exits, like the judgment of the Constitutional Court, are more dangerous for the EU than exits like Brexit. But then thirdly, I will also say that the UK is now semi-exiting from the withdrawal agreement, which creates now new challenges for the future of Europe. So on the first point, and I think that really goes to the title of our seminar, I think both processes like the withdrawal of the UK from the EU and judgments like the German Constitutional Court ruling in Weiss ought to be considered together as instances of legal disintegration. Why do I consider them as cases of legal disintegration? Essentially because I see them as the opposite of a legal integration intended as integration through law. So this has been a point that was made previously, that the EU legal order, the EU as a project was since the very beginning a legal project. Integration happens through law. We don't have an army or a police force in Europe that keeps countries together. It's just the law and respect for common rules. And from this point of view, both the decision to leave the EU legal order, which is what the UK is doing through Brexit, an exit from the EU, but also in my view, what the German Constitutional Court did in its recent judgment, which is not leaving the EU, but at least disapplying part of EU law, are to be seen, I think, as cases of subversion, as Amelie said. And in this respect, I actually I find very interesting a piece that Mark Dawson authored recently for the German Law Journal. I just want to cite the title, which is Coping with Exit, Evasion and Subversion. Now, he said he doesn't think the German Constitutional Court judgment is part of that, but I think he rightly pointed out that we are indeed facing this challenge of legal disintegration. Having said that, and I move to my second point, I am in agreement here with Dan in thinking that semi-exits are actually more dangerous for the EU than exits. Now, Brexit is a messy process. The Brexit Institute has been tracking the process for 3 years already. But I think, at least in Brexit, you have a more orderly procedure whereby a country decides it doesn't want to be part anymore of the EU. It uses Article 50 of the treaty, which is there and allows it to leave if it decides to do so. And it does so in a more sort of procedurally managed way. On the contrary, I am worried about the judgment of the German Constitutional Court because it leads to a situation where every court can pick and choose which part of EU law it wants to abide by. And I think this is seriously dangerous because the foundation of the legal order are called into question. And Daniel Kelemen and I, with other colleagues, have argued this point also in a number of public statements, that we think national courts cannot override ECJ judgments because indeed semi-exits pose a major threat to the future of the EU. But moving to my very last point, what I think is ironically happening is, I said Brexit is slightly better than the German Constitutional Court ruling in terms of, I think, respect for the rule of law. But of course, as Lord Thomas has explained to us at the start of our webinar, now the UK is semi-exiting the withdrawal agreement. So we have a legal treaty negotiated on the basis of Article 50 that regulates the terms of exit, but with the introduction of the Internal Market Bill in the House of Commons earlier this week, effectively the UK is now trying to renege on what it signed up to, or again, to semi-exit. So the Internal Market Bill is not in breach of all the withdrawal agreement, but it is violating selective provision of the treaty, which I think will raise a number of really interesting legal questions moving forward, because as some of you might know, Article 4 of the withdrawal agreement states that the withdrawal agreement will have in the United Kingdom the same effect that EU law has in all of the member states. And when it says that, it basically says the withdrawal agreement has direct effect, but also supremacy in the UK. So even though Lord Thomas is no longer a member of the judiciary, I'm sure some of his colleagues will have to be soon dealing with the question whether an act of parliament could be in breach of a treaty that says that its provisions are superior to subsequent contrasting laws. In any case, there is no doubt that the processes we are seeing both in the United Kingdom with the Internal Market Bill and with the German Constitutional Court in Weiss do raise new questions about compliance with the rule of law. And of course, this is a broader phenomenon that it's raising challenges across Europe in the recent years, and one problem with which I think generations of lawyers will have to deal with. In the interest of time, I'll stop here and I'll hand back to Mary, who I know will be collecting some questions as well. Thank you.
Thanks, Federico. So as I said earlier, you can submit your questions on the web chat function there on the bottom right of your screen. So the first one here is to Lord Thomas, and it's from Polly, and it's a question on the role. Do you think the role given to the CJEU in the withdrawal agreement dispute settlement mechanism is an important stumbling block to the UK's willingness to use it?
No, I don't think so, because it's a fairly limited role. What's important is the arbitration mechanism, and what's wrong with it is it doesn't operate quickly enough. Anyone with experience of disputes knows that one of the most important things to have is a mechanism that will operate. Now, of course, the CJEU can be used as a smokescreen, and no doubt will be, but I don't believe that's the stumbling block. There are two. One is that the mechanism for dispute resolution is not as fast and speedy as it should be. But two, and this is which ties together what we've been talking about, I don't believe there's a proper respect for the rule of law. That means where there is a dispute, and disputes are inevitable, there must be a willingness of states and of governments to abide by the rule of law and refer things to decision-making and not take unilateral action. And I think that applies right across the board, whether it's internal EU issues or whether it's interstate relations, and certainly it applies to the way in which courts should be allowed to operate independently.
Thank you. Thank you. Could I just put a question there to Mark? You mentioned loyal opposition and how that's fading as a concept. Do you think that that is kind of diminishing, that idea of loyal opposition, because of increasing polarization in politics?
Yeah, absolutely. I mean, sort of, you know, I think this was mentioned by sort of Lord Thomas at the beginning. I mean, the whole idea is based on that even if we're political adversaries, we're bound by sort of common principles of decency, right? So I mean, in the Westminster parliamentary system, this is often symbolized by, you know, having ruthless debates in the parliamentary chamber and sort of going for a drink afterwards and talking about your kids, right?
Yes.
You know, and the difficulty is whether we've sort of gone beyond. And I think to make a very quick analogy to the legal domain, that's why I slightly disagree with Federico about things like infringement actions against the German Constitutional Court, because I think ultimately, you know, the German Constitutional Court, like other constitutional courts and the Court of Justice, have to have a sort of cooperative relation. And once one sort of weaponizes that relation, once one sort of uses a third actor, actually a political actor like the European Commission, to then bring an action that could lead to some form of sanctioning or pressure the German government to sanction the court, you know, that would sort of potentially poison what so far has been a rather chummy relation, actually, you know, sort of while in the judgment themselves, they criticize each other, actually afterwards they go to FIDE and other conferences and they, you know, have dinner together and that sort of thing. So I think we have to, maybe there's some stretching the analogy a bit too much, but this is how I would see it.
Thank you, Mark. Thank you. I have another rather kind of a technical question here from Anna Bobic. So Dan Kelemen mentioned that every disapplication of an ECJ judgment results in the falling apart of the EU legal order. Could you comment on how this has evidenced itself after the Dansk industry judgment of the Danish Supreme Court, which is in remedy, in fact, stronger than Weiss, given that it issued a temporary remedy to a national organ, whereas the Danish court directly ruled that a judgment of the ECJ is ultra vires. Thank you. And that's to anybody who wants to take it on, I think.
I can say something quickly about it.
Yes.
Yeah, it's true that there have been, as Professor Bobic says, some other recent incidences of this kind of defiance of ECJ rulings. And I would say it's not that one ruling automatically leads to the immediate disintegration of EU law or something. That's not how legal orders are built or how they disintegrate, right? But rather, when one has these kind of rulings, and if they go unresponded to, then let's say those kind of judgments from national courts can proliferate, and then gradually the system starts to disintegrate, right? Just as it's not like the first day that supremacy was declared by the ECJ, supremacy became a fact on the ground across the member states. These things are developed gradually. And I'd say, what we've seen in recent years is, just stirrings of growing defiance from national constitutional courts of the authority of the ECJ. And when a kind of court that has the status almost of a primus inter pares, like the German Federal Constitutional Court on these issues, does what it did, that has even more resonance across Europe than similar rulings from other courts.
Thank you. Thank you, Dan. I have another question here. What is the panel's view on the government's claim in its paper issued today on notwithstanding clauses that certain actions of the EU relating to Great Britain, Northern Ireland goods transfers could be in breach of the good faith obligations under Article 4 of the Withdrawal Agreement and/or Article 6 of the Protocol on Ireland and the North? Anybody like to take that?
Perhaps Lord Thomas.
Well, can I just get back? I think what is important is the British government has one view, the EU has a different view, which is right. I haven't the faintest idea because I'm not privy to what's going on. But what is important is that you don't act unilaterally. If there's a dispute, you must actually deal with it in accordance with the rule of law. I think it is very, very simple. And I simply don't understand why you don't take a dispute and dispute. I tried to explain at the beginning, the protocol is a very complex document, and it was drafted which in a way left many very difficult questions to be answered. And it was hoped these would be agreed. If they're not, you don't throw the agreement you've made away. You actually go to someone and ask them to resolve the difference. And so I won't express a view as to whether who's acting in good faith or who isn't. But if there's a difference of opinion about it, then this is a classic matter to be resolved by the dispute resolution mechanism.
Okay, thank you. Dan, yes?
I'll just quickly add, I'll be more impolitic and say I think it is clear who's acting in bad faith here, and that is the United Kingdom government. Because, I mean, the whole point of the revised withdrawal agreement in the Northern Ireland Protocol and how it departed from the previous Irish backstop, right, was the Johnson government wanted to get rid of the possibility, which would have been part of the Irish backstop, that the whole of the UK would have stayed in the customs union, right, and in the single market for goods, at least partially. And so they knew very well that they were agreeing to a border down the Irish Sea in terms of some customs checks, right? They knew that very well. And now they're just lying about it because, turns out that's very uncomfortable to do to your own country.
Thanks, Dan. Anybody else want to come in on that question?
If I can just jump in as well, I mean, to develop my point, I was trying to make in my remarks at the end. I think it's quite interesting how perhaps this is too much of a technical discussion, which hasn't come up in the political conversation about the withdrawal agreement, but sorry, it hasn't come up in the conversation about the internal market bill, but the withdrawal agreement has a specific provision, which once again is Article 4, and it states that this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member states. Now, again, it might be that the United Kingdom was not aware of what it was signing up to, but I think it's very clear that this provision is designed to preserve direct effect and the supremacy of EU law principles in the UK after Brexit. So I think this is going to create quite a headache for British judges, which are used to the idea of the supremacy of Parliament, where no Parliament can bind the next one. Because here again, if you embrace the rule of law approach that Lord Thomas was defending earlier on, you have a situation where the United Kingdom has signed up to a treaty which basically gives to this treaty constitutional status within the UK, so that no subsequent act of Parliament can be in breach of the treaty. Now, in a country without a written constitution, I think this raises particularly complicated questions, but my reading of the withdrawal agreement convinces me that this is actually the net effect, that so British judges would need to disapply the internal market bill if it becomes an act, because it is in breach of the withdrawal agreement. But I suppose the issue is still up for decision, and maybe Lord Thomas has a different view of that.
I don't want to monopolise what is an interesting conversation about an important EU case. But if I can just briefly say, one, because of our approach, because of the UK court's approach to international law and to domestic law, there is a particular provision in the Internal Market Bill, which, if it becomes law, which expressly disapplies that part of the protocol. A question will arise, well, do the very clear words of Parliament abrogate the UK courts from doing what an international treaty says they should do? There will be an argument about this, but what is obvious to my mind is that actually doing this, unless there's a justification for repudiating the protocol, is plainly and absolutely contrary to the rule of law, and for that reason should not be pursued. This is why I think that adherence to the rule of law, once you break it, you open a Pandora's box. How do you persuade people to obey regulations, for example, about social distancing, if you, as a government, set an example that you can breach the rule of law? I mean, these things have very profound implications. And I do think, looking at the UK, looking at bits of Europe, particularly Hungary and Poland, and looking at one or two other states, the respect for the rule of law as traditionally understood in the West is becoming a bit more like the rule of law, sometimes described as the rule of law with Chinese characteristics.
Thanks, Thomas. Just on a slightly related question, it's from Giovanni Zaccaroni, and he asks the panel, do you think the UK Supreme Court could be involved in the evaluation of the compliance of the Internal Market Bill with the withdrawal agreement? And if so, how? Anybody like to take that? Is there a role for the Supreme Court here?
Do you want me just to say something? I really just repeat what I've said, is that I think the amendment to which the Prime Minister has agreed will allow this matter to go to the Supreme Court. But the traditional British view is that if if our treaty obligation says A and domestic legislation says B, the traditional view normally is that you apply B. But whether that will be the case in this case, I think it remains to be seen.
But if I can follow up on this, John, it's very interesting because, of course, the EU negotiator explicitly wanted Article 4 in the withdrawal agreement to make sure that, for example, citizens' right or the Northern Ireland Protocol or the financial obligation of the UK could not be later in the day be overruled by a next parliament. So it really goes to the point about semi-exit. Can you allow that to happen? But if you don't allow that to happen, then perhaps Brexit can never be fully achieved. So I think it is an interesting aspect of the case.
Thank you, Federico. So interesting question here from Alex White directly to Mark Dawson. Do Mark's pluralistic views and his call for a more relaxed approach to the Weiss judgment, would that be an immensely more difficult argument to make, or a solution not found in Germany in the other courts?
I'm not sure if I understand the last part of the question. Could you repeat it?
So the solution was found by reference to the other courts in Germany?
I mean,
so if you're making for... Go ahead.
No, I mean, the ultimate solution to the judgment is the one that Amelie mentioned, which is basically the European Central Bank provided sort of certain evidence, impact assessments that then was sort of satisfied the Bundesbank and presumably will also satisfy the German Constitutional Court, that sort of the principle of proportionality was complied with. I think one of the questions, of course, here as well, and it's a little bit relating to the concerns that Dan Kelemen and Federico have, sort of how is that then received by other constitutional courts? Is that then an invitation towards this kind of slippery slope that Dan referred to, right, of other constitutional courts also following the approach of the German Constitutional Courts? I think the more optimistic reading of this is to make an analogy, I think. So think about, for example, EU fundamental rights. Again, this was an example where Germany was often a pioneer. You had contestation of EU law from national constitutional courts on the grounds that EU law didn't comply with fundamental rights standards. And what you saw gradually developing is a certain commonality of approach between different constitutional courts. So different constitutional courts gradually sort of tried to develop certain standards by which they'd assess the European Court of Justice's action in relation to fundamental rights, by which they'd make preliminary references to the courts where there was a potential violation of fundamental rights standards. And of course, that's the question of whether we might have something similar in the case of ultra vires review. So in this case, in the Weiss case, the German Constitutional Court had certain safeguards. It says, well, we'll only allow ultra vires review when there's a structurally significant change of competences. We'll only allow it where we've already had a preliminary reference before the Court of Justice. So of course, now the question is, well, do other constitutional courts also adopt those sorts of standards? And therefore, do we have a sort of common approach developing between national courts about how they apply ultra vires jurisprudence? I'm not sure if that's an answer to the question, but...
No, that's very interesting, Mark. So I have one more question here for Amelie. And since you're based in Paris, I would just like to put this question to you. To what extent do you think the Weiss judgment is problematic because it could be viewed as economic politics dressed up as law? And since Germany has always been adverse to loose or inflationary monetary policy.
Yes, well, there was definitely, I think, in let's say, a political aspect to the judgment, insofar as it essentially found that the ECB had exceeded its powers because its monetary policy decisions had too much, let's say, of an economic effect, whereas the economic sphere is supposed to be within, at least the fiscal sphere is supposed to be reserved competence of the member states. And so behind what was legal language and discussion about legal competence was indeed essentially a political opposition to the decisions of the ECB, finding that the ECB was exceeding the scope of its monetary policy powers. So I agree that that's definitely the case. But ultimately, the solution to the problem was also political, as I mentioned. The German government decided that the actions that the ECB was taking, not only as part of the previous purchase program, but also obviously in light of the COVID situation and the new COVID-related purchase program, that those actions were necessary, and ultimately, I suppose that's how I read the solution, favorable to Germany. And so not, in fact, contrary to Germany's economic interest. And so I fully agree that behind the legalistic implications of the judgment are political decisions being made. And maybe one point, I'll take this opportunity to address something Dan said about the nullification doctrine in the US. The EU is, of course, not a federation. And so I think that while this judgment was particularly shocking for all the reasons I mentioned, there is room for dialogue and discussion between the EU level and the national member state level in what is a treaty-based organization and not a federation. And as someone I think in the questions pointed out, this dialogue is nothing new. It happened with Denmark, it happened with France, Italy. There are several cases in which national constitutional courts have disagreed and have had, in some cases, valid reasons to do so in an organization that is based on conferral of powers and not federal powers. I think that ultimately, though, the way in which this should be dealt with is through dialogue, and not, as others have said, not in a unilateral manner. And I do think that when this is not complied with, there is actually also, to make a comparison with the Brexit situation, there is a dispute resolution mechanism, and that is actually the infringement proceedings. And the infringement proceedings should be used because they are part of the legal system. They're provided for in the treaty, and that's what happens if there is a disagreement between the national court and ECJ. Infringement proceedings can be started, and oftentimes they are, and they have been for France, they have been for Italy, and that has led to that dialogue, and that has led to a resolution of the issue that actually preserves the legal order. And so I wouldn't be as pessimistic about any decision that contravenes EU law being a sign of disintegration. I think the dispute mechanisms that already exist within the EU legal order should be used, and should be used in a constructive way.
Very good, thank you, Amelie. There's another angle on that whole question here from Annelieke. So she points out that there has been some changes to the German Constitutional Court. The new member is significantly more pro-EU, likely tipping the balance the other way. What would be the impact if the German Constitutional Court came back from its own decision in a similar case? Rode back from its own decision, I think. Does anybody anything to say about that?
Maybe Mark.
Indeed, so the composition of
Yeah.
the Constitutional Court is often changing. Also, sort of the person, the architect, or one of the architects of this sort of more Eurosceptic, one might argue, from a certain perspective, line of judgments, has sort of retired from the courts. So there are sort of these changes, but I mean, you know, it's largely a court that sort of bases its jurisprudence on kind of consensus-based principles, right? And I think you can see that in the way this jurisprudence unfolded. So, I mean, although I think from many perspectives it was a very surprising judgment, many of the things, of course, that came to pass in the Weiss decision, they were already part of the previous litigation, the initial Gauweiler litigation, where again, the composition of the court was different. And of course, many of the broader issues in terms of the way in which European integration, the relationship to national German law and European law is seen in Germany stretches way back, to the 1990s and 1980s and beyond. So I'm not so convinced that sort of, changing one person is fundamentally going to change the German Constitutional Court's approach. But I also don't think that we're going to see sort of a lot of ultra vires decisions, right? I think sort of they really wanted to make a point. They decided that EMU was the place to make this point because of the scale of the program involved, because of the nature of the effects on German political economy. They've now made their points. A political solution has been found. And I would suspect that sort of that is the end of the story for now, at least.
Mm-hmm. Very good. There's just one last question here.
Mary, Dan wanted to step in as well.
Oh, I'm sorry, Dan, go ahead.
Oh, yeah, I just wanted to add something on sort of the legal disintegration questions. And I very much take Ms. Champsaur's point about dialogue. And I think dialogue between national constitutional courts and the ECJ, obviously that's been a big part of construction of the EU legal order. It's a good thing. And I think it can solve 95% of the kind of problems and tensions. But then there's the other 5%, right? And Weiss itself is an indication in the sense of the failure of dialogue, right? But if we go then to Poland, I just want to say something because we really haven't gone into specifics in terms of legal disintegration. This isn't hypothetical, it's already happening, right? Dutch and German courts are now refusing to do extraditions under European arrest warrant to Poland because of their concerns, which are 100% legitimate, that people won't be able to get fair trials there. Now, it's not going to stop with European arrest warrants. It's going to go to the Brussels regulation, the mutual recognition of judgments, and eventually you can have the breakdown of the single market because, after all, why should courts have faith and trust in courts in authoritarian regimes? They shouldn't, right? And so, dialogue is great, but dialogue with autocrats is bad, I think, and it doesn't work. Right. So I think any system that relies on dialogue has to have structures that are robust to the grim realities we face today.
That actually makes me think, Dan, that maybe we should have an exit mechanism built in to kick out some member states instead of just allowing them to leave.
Well, I think that would be great. There's problems with that because how about all the citizens who are the oppressed citizens, right? So, but in any case, it doesn't exist in the treaties and it's not going to be cooked up. Again, as we said, the problem isn't that states want to leave, it's that they want to stay and take the money, right? And all the benefits, et cetera.
Okay, I think we're almost out of time, so I'm going to hand back to Federico now to wrap this up.
Maybe, Mary, we still have time for one final question. I know you were reading it just before I interfered.
One quick one there. A question to the entire panel. Do you think the recent orders of the ECJ on former Advocate General Sharpston can weaken the position of the European Court of Justice in defending the rule of law and ultimately facilitate legal disintegration? Anyone?
Maybe very quickly, I personally think no. I think one of the dangers is that we just put a little bit too much into the rule of law basket, right? So every action that sort of might lead, to some threat to independence of an independent official, where there's also a compelling other interpretation of that particular action, should not necessarily be seen as equivalent to other rule of law violations, right? So there is a very compelling reading of the treaty that would suggest that sort of there were reasons actually to dismiss this action, as well as readings of the treaty that would suggest there is a legal claim, right? And I think in those circumstances, saying that sort of that's equivalent to the kinds of rule of law violations we see elsewhere, I think that's sort of putting too much into the rule of law basket. So I would be a bit cautious about that.
Thanks, Mark. Anybody else?
I will just say that back in 2017, I had authored a report requested by the Constitutional Affairs Committee of the European Parliament, where my legal position was that members of parliament elected in the UK and judges appointed by the UK should serve until the end of their mandate. But I shall say my position was ultimately not successful, because we've seen it indeed with MEPs elected in May 2019. In the UK, they all left the parliament. So I think the AG situation is actually a follow-up to that, but indeed it is a relevant issue.
I think that's all the questions that we have. We fielded them all.
Okay.
Thank you.
Okay, so I think perfectly on time, I'll take over from Mary just to thank her very warmly for chairing and moderating the discussion. With my hat on as founding director of the Brexit Institute, let me also take the opportunity to thank warmly all the speakers, Lord Thomas, Dan Kelemen, Mark Dawson, and above all, Amelie Champsaur, whose law firm, Cleary Gottlieb, was kind enough to sponsor this event. Let me take the opportunity to thank also our core sponsor, Grant Thornton, AIB, and GSK Stockman, as well as the European Commission, which is indeed funding the bridge network we run at the Brexit Institute. And finally, of course, let me thank the audience for being with us in the afternoon. As my president, Professor Cjeu, said, the Brexit Institute will be organizing within the Bridge Network project a conference on the 1st and 2nd of October, which touches also on the European Central Bank and the Weiss judgment. So I encourage you to follow us there. And then let me already announce we will run a big event on the 15th of October on Brexit and the US presidential election, which is coming up very quickly, and as we are witnessing, is already having a significant relevance on the Brexit story. So even though we cannot meet in person, we're very active live, so please stay tuned. Thank you very much again, and stay safe. Bye-bye to everyone.
Thank you.
Thank you.